if you're not engaging exposure scientists initially, then you're playing catch up the entire time.
You've entered Legal Al, where sharp legal minds meet the power of strategic intuitive intelligence and inner awareness. Hosted by someone that is a veteran, an author, and is an individual experienced in specialist security operations, strategic intuitive intelligence, and transformational psychology, this is not your typical legal podcast. We explore what most lawyers never say out loud: burnout, grief, inner dissonance, and what it really takes to sustain a legal career with clarity, purpose, and personal alignment. Alongside powerful solo insights, you'll hear thought-provoking conversations with members of the Help Lawyer Network, lawyers, legal support professionals, and expert witnesses, sharing real stories from the front lines. This is the space where law meets what's rarely talked about. Welcome to Legal Al, where wisdom meets the law and strategic intuitive intelligence guides the way.
Good afternoon, good evening, good morning, ladies and gentlemen, wherever you are in the United States. This is John here. This is Legal Owl, and today I've got a fantastic guest. You've probably seen him on one of our episodes before, but the reason I've brought him back is because I'm seeing in the news lawsuit after lawsuit regarding Legionella pneumophila and deaths that are happening, from cooling towers to even HVAC systems. Legionella is becoming a bigger problem. But is the legal industry ready for what's going on out there? There's obviously going to be an increase in cases as we move on. What do you as a lawyer need to know? What do you need to know when you're working with an expert witness? And today, this is why I have brought back Dr. Alex LeBeau from Exposure Consulting, who is not only an expert witness, a toxicologist, an environmental scientist, and an expert in Legionella. And he's going to talk about what you need to know as a lawyer moving forward, especially as things change. And we're getting into the weather that is the perfect storm for Legionella pneumophila. I keep saying that wrong, ladies and gentlemen. I used to say pneumophilia. But Alex, welcome back to Legal Owl. How are you, my friend?
I am well. Thank you for having me.
So I'm seeing, Alex, I'm seeing a lot. I get updates, things from Google, news updates. I see things in New York Times. I see things in New York Post. And it seems to be every other day there is an outbreak or someone is dying. I see that recently a lot with the cooling towers in New York. We've had cases in the past in military establishments and hospitals. And so Legionella seems to be a growing issue. And what I'm finding is that it's way beyond what anybody's expecting now. We have problems in the water that's dispersed in fountains, but now I'm seeing people are being infected through the air conditioning HVAC system. So why is it getting worse?
I think there's two prongs to this. Is first of all, it's increased recognition, understanding looking at the science and seeing that more and more people are actually being exposed, testing for it more. And there's people that are physicians that are maybe in emergency rooms when people come in and say, oh, maybe we should test them for Legionella. Because a lot of times, historically, you may look at someone who has a pneumonia and say, oh, that's just a community-acquired pneumonia or whatever it is. But now more and more, they're like, we need to do some additional testing to confirm maybe what the source is, see if it's Legionella or not.
And I think is when people are identifying then that it is Legionella, because I notice, there's a friend of mine who has recently contracted Pseudomonas, which is perhaps maybe there's a connection there where, it could be Legionella, not Pseudomonas. And then it becomes a legal issue, and lawyers are then faced with potential lawsuits and plaintiff cases and defense cases. What is it the lawyers that need to be aware of? Because obviously, like I'm seeing recently, there's a lot of lawsuits that are coming up in this field.
Yeah, I mean, there's people obviously if you feel like they're harmed or there was some negligence that occurred in some scenario that you were exposed in, yeah, you want to find out, how you've harmed me, how can I be compensated for that harm? Sure, I completely get it. However, there's lots of things from a scientific standpoint that people have to understand getting from linking the exposure to that one particular Legionella bacteria to the Legionnaire's disease outcome. There's a lot of steps in between that. And what I have identified or observed is that a lot of times there may be a few, I'll say, firms that are used to handling the cases from the exposed individual side, but when it comes to the defense of those particular facilities where the exposure is being claimed, that they may not have the vast experience that others do because they may get one case a year or one case every few years. Or I've heard from a number of different attorneys that say, "This is my first case. And what do I need to know?" And that's like a let's have a little course.
And you know what? There's going to be a lot more of that, and I'm glad that you will actually be teaching a CLE class in help lawyer on what to know and what to understand about Legionella. We've already had CLE approval for other classes that we have, and so that will be coming up. So if you're a lawyer out there and you want to be ready for this, then this will be coming very soon, and it'll be Alex is teaching it. But I want to go back to something that you said, Alex, because you said they come back and they're like, "This is my first case." Now, this is obviously going to increase because, as you've mentioned before, I've heard you talk about before, we're testing more and more and more. And the ability to test is getting, the technology is developing even more. You're getting faster results that are coming in. And so, do you feel that lawyers are off guard? Do you think they're caught off guard because this comes up?
I say that, when you're looking at these kind of exposure tort cases, if you want to call them that, eh, it's if you're not engaging exposure scientists initially, then you're playing catch up the entire time because chances are the person on the other side has handled these matters before, knows what they're looking for, maybe has a few experts they work with often that kind of help them out and say, what are the major hits that I need to worry about in this scenario? And it's easy for them to identify those. Whereas if if you're engaging me at the last minute, I'm at a disadvantage to assist you in that process because there's already so much that has mounted up that I have questions, and I've been involved in matters where I say I need answers to this, and they say, "Well, I can't get you answers, and sorry, your deposition is tomorrow." And it makes it difficult for me to respond when those scenarios when there's not enough time for me to get all the answers that I need to have a clear picture on the scenario.
Do you think that's down to the actual attorney? They don't have enough knowledge themselves on perhaps what Legionella is, even the causation of it, and the pathway of Legionella. Because if they understood it more, would that help them to say, well, we can't go to deposition now. We have to wait. We have to gain the intelligence to be able to make an assessment or even to defend.
I think that knowledge would be super helpful to, understand even when it comes down to the individual claiming the exposure. There's things that I like to know about their exposure. I want to know maybe A, B, and C, what went on in their life, not only 2 weeks, but a whole month beforehand. What did they do? Think of the nitty gritty details of where else they may have been exposed. And, if I get engaged later on and I hear, well, we already, deposed the claimant and we can't ask those questions now. I didn't ask them then, so I don't really have the answers for you. I'm sorry. And it makes my job more difficult to try to figure out kind of what's going on because usually, and I'll tell you lately, all right, let me take this step back. I want to get involved as soon as possible. So if it's hey, we got a notification that's last month someone's exposed, send me out to the site. Let me see what's going on. Let's do an assessment, figure things out. Because if I get a notification for, oh, this happened 3 years ago, it makes it a lot more difficult on my side to get the answers about what was going on. And from the forensic and analysis standpoint, there may not be sufficient documentation for me to get all the answers I need. I keep asking questions, and I still like to see a site, but it makes my job more difficult if you're not getting me on board immediately.
No, you just you're just it's a perfect segue because you mentioned that word on board, and it's just tweaked something for me. Because recently I noticed that you were mentioned in an article. I can't remember the magazine, but you were in an article with another lawyer. I think a lawyer who's in Miami. We're not going to mention his name at the moment because we don't have any cases that he's on. But he was involved in the cruise industry, and you were both experts within this article that came out, and you can mention that magazine if you want, but that article that came out where you talked to people that were booking cruises, and that in the cruise liners, there seems to be a bigger problem with contracting Legionella. And obviously, he works in this field. So, if we talk about what is it that the public need to understand, but more so what the lawyers need to understand, because this person who's maybe been on a cruise ship has got ill, comes off, hires an attorney, and the attorney has not got enough information, especially when it's dealing with something like cruise liners, because isn't there another law, a maritime law, where it's off the land, and does that change things for you even as an expert?
Cruises are interesting because, and all right, I'll set the stage for you. Is that usually there's CDC guidance that has to be followed for cruise ships about testing and Legionella and water quality and everything. So there's people that are usually doing a lot, that are supposed to be doing a lot of testing on the cruise ships and the water that's stored on them, because when you have, I'll say, storage of water like that and you're heating water, there's lots of piping in a cruise ship where you could, where Legionella may like to kind of harbor itself and grow. So there's a lot of attention to that on cruise ships if they're doing things correctly. As opposed to, I'll say, domestically here in the United States, where if you think of your local water utility, they have to follow the EPA rules for clean water, for drinking water standards. But one thing that is not regulated by EPA is Legionella. So they regulate, I'll say, disinfectants that are in there. Disinfectants are meant to keep the bacteria at bay, and they presume that when they have sufficient, quote unquote, sufficient disinfectant in there, it's keeping that Legionella uh, on a non-detect level. But they don't test for it, so they don't know if it's actually like that, because some water utilities, I'll say, are more proactive. I'll say that's very handful of them in the United States. You think of all the public water utilities, there are thousands. And they're not testing for Legionella generally or overall. They're just relying on surrogate measurements to do that for them, as opposed to cruise ships that should be testing. But you also think about cruise ships, they go lots of different ports. There are lots of different exposures, other countries that they may visit on their outings when they dock may not have the same requirements or testing that maybe they go. For example, I went on a cruise ship and I was able to go to a water park. I don't know what that water park does. Was that the exposure point for someone as opposed to the cruise ship? And they're just associating it with the time in the cruise ship, but it was actually the water park that was the relevant exposure. So cruise ships are unique, that there are things that they have to do. There's usually more data that should be supportive of that. You know, what the robustness of that data may depend on the cruise line. Same thing domestically. When you think of water and facilities, general consensus standard says that the facility's ownership and management is responsible for the water quality within that facility, because they recognize that the local water utility doesn't test for it. So it puts the responsibility on the owners and operators of these buildings to do the testing and establish a plan and everything else. And if you don't have a plan in place, it makes a lot more difficult to kind of I'll say, understand what the data is. Now, that you may have elements of a plan. You may say, well, we do the testing, we do all this stuff. We don't have data in any centralized spots all over the place. And we don't have anything written down really, but we just have all the stuff that we kind of do. I still have to look at it. I can probably get a semblance of something and go, okay, that makes sense. You have the elements of a plan, but it it makes my job more difficult. That data is not even in place. But again, cruise ships typically do have those, but again, it all depends, I think, on the line, how robust that is.
Is the plan an Achilles heel legally? Because obviously, and here's the thing: a lawyer comes into a potential case, there's a potential Legionella lawsuit, and they don't understand Legionella. They don't understand the path of transmission,
Mm.
because how many lawyers out there would understand where it actually comes from, and how the biofilm and what kind of organism it is and how it actually transmits. But then a cruise liner, say it's in a defense case, the cruise line says, hey, we got a water plan. But then the water plan's not enough, and the attorneys don't understand what they're looking at in terms of what a water plan should be. So in your experience, and historically in the cases that you have been involved in, where do the attorneys fail? Or, for want of a better expression, where is their Achilles heel? Where's their weak points?
It's when it comes down to looking at the data, it in my opinion, I'm sitting on one side of this or the other. It's low hanging fruit for someone to say, you don't have a water management plan. You're supposed to. Everyone does. And it starts to look bad that maybe a place doesn't have a plan, or even if they have a plan, you have to understand the robustness of your plan. So I've been involved in matters where they have a plan and every line in the plan says to be completed, and no one's completed the plan. It's just the shell of a plan with very little basic information in it. And that's again, that's easy. Now, it takes more time to explain that and go, okay, well, those are just placeholders. I see here it's got this. It muddies the water. It's much easier to have a very streamlined scenario where you can look at it to begin with, even if we're not involved in the lawsuit. Have a third party oversight of your water management plans to say what the deficiencies are, because there's lots of companies out there that will sell you a water management plan, but when it comes down to it, um, and they are literally from looking at the plan, they're just selling you the bottom basic without completing it, and they put a responsibility on you to do it. And if your folks are not familiar with it, they'll say, "Well, I guess they gave us what we needed." So having a third party look at it and go, okay, this is what you actually need to do. This is the shell. These are the basic elements, but you need to do a little more. That's helpful later on. And there's a point. It's important to understand or point out that this is a consensus standard of care. This is what I'll say. General people in industry will do this. There's no law that requires this. There's nothing that EPA says you have to have a water management plan. There's other organizations that say you should have one, like the Joint Commission for healthcare organizations. CDC talks about having water management plans. ASHRAE is I'll say standard kind of guidance organization that requires or that says you should have these plans, but nothing in law that I have seen says you have to have this. So that's an important detail. But when it comes to questioning and they say, well, everyone in these relevant fields says you're supposed to have it, and you don't have it, it makes things look like you're trying to be evasive and uncomfortable, and it messes the water up, so to speak.
How do you defend against that, Alex? I mean, if you are acting in defense of, say, a hospital or another organization or a cruise liner, and they don't have a water management plan, and there has been a contracted case, how do you potentially defend against that when there are so many weak points? If you're working with a law firm and they're like, hey, Alex, look, this is the issue. There's now a lawsuit. We don't think this is right. But they didn't have a management plan. What are you going to be asking the lawyers? What information do you need?
I want to see what data is available from water testing, water quality testing. If their state or local health department requires them to have their pool tested, how many do they have to, do they have to test it daily? Does a health department come in twice a year to do it? What data do you have? Have you ever had any of your water tested? Do you have a third party company that handles that? How often do they come in? Looking at all of that, and it's not a small amount. And I don't want to see just the time. I don't want to see just the month that they were exposed. I need to understand what historical trends are. I want to see maybe the previous year, because what I've found out is when people become complacent, you can track that complacency maybe on a monthly basis in their logbook. And you can say, oh, well, it looks like they do this every 5 days, or they have a deficiency or something that catches my eye. And I want to bring it to your attention before it gets to that question of making things uncomfortable. I want to look at trends, because looking at this from forensically backwards, that's the stuff I'm looking for. I'm looking for not only what data is there, but what data is not there, what we call data gaps.
I want to, if somebody, for instance, here's the other thing I was thinking of, and again, it can be anything in the healthcare industry, in the travel industry, anything like that. Somebody gets on a cruise ship or anywhere else and they contract Legionella. But what's to say, Alex, that if you're defending the company for the lawyers, or even if you're on the plaintiff side, what's to say that they didn't contract it outside? How do you identify that then for a lawyer? Like, what are you looking for? Because they're claiming I was on this ship, I showered, or I was in the pool, I got Legionella. But what if they contracted it before they came in?
What I like to and that's a great question. And what I always have this conversation, especially if there's folks who haven't handled this before, is I'll identify what's generally referred to as the gold standard for linking an exposure with a case. And I'll describe that to you hopefully quickly. If someone presents with Legionnaire's disease, now it's important to understand that upwards of 90 to 95% of the cases here in the United States of Legionnaire's disease are caused by Legionella pneumophilus serogroup 1. There are a number of different serogroups. Serogroup 1 is the one that most often causes Legionnaire's disease. There are a few others that may and do, and some data that show it, but the predominant one is Legionella pneumophilus serogroup 1. So if they have LP1, they test positive over the hospital, and in the hospital, they collect a sputum sample from the individual, coughing up something from the lung, and that's sent into a laboratory at the hospital, and they grow Legionella on the petri dish in the hospital laboratory, in the clinical lab. They send that off for genetic testing to understand what the genome sequence looks like from it. At the same time, if someone goes out to a site that they claim that they were exposed at, and this is hypothetical, they take water samples, send it off to a laboratory for culture. That culture identifies LP1. If LP1 is detected in that culture, see if it's growing at a growing rate. It has there could be presence of LP1 versus growing and amplification of the bacteria, and it has to be growing and amplifying to be, I'll say, a human health risk. Send it off. If it's identified, send it off for genetic testing and look at the genome sequence of that and matching the environmental isolate to the clinical isolate. And if those can be matched, that would be, I'll say, the gold standard for identifying an environmental exposure to one particular place.
Hi, if you are a legal expert or an expert witness and you would like to join our exclusive legal community, then connect with me on Help Lawyer and let's have a conversation. That's fascinating. So you can tie that down to a particular area. Because I was thinking as well, like, I mean, I live here in North Carolina. There was a massive case here at the local fair in Asheville. And,
Mhm.
you had so many people, there were a number of deaths. And then I'm thinking as you're talking, yeah, but what if that person has been at the fair and then goes on a cruise or flies somewhere I
Right,
find that
and
fascinating that you can identify the area just by that sequencing. And as a lawyer, I would be looking at that. Where is the weakness in the defense or the case?
if you can get out there in enough time, if everything's done. Now, I'll say there's lots of things that get in the way. It may not be timely for you to go out and do an environmental sample. Maybe you don't find out about this for 2 or 3 weeks or 2 or 3 months. What if there's no clinical isolate done in the hospital setting? You know, I've seen it a number of times where they say, "Oh, well, we've requested cultures, but we cancel them once we identified Legionella in what we call urinary antigen tests. Once people are positive on the UAT, they may cancel the culture, so you don't have that data." The culture and the Legionella in the environmental sample may no longer be growing after 2 or 3 months. There may have been seasonal changes or changes in concentration or use patterns at the facility where the Legionella is no longer detectable. So that's why I say if you can find out about it very quickly, and if you do, get someone out in the field very quickly to find out, kind of see if you can do that match. Because everything I won't say everything. A lot of things that are below that environmental and clinical isolate matching are, say, the silver, bronze, and participation trophy kind of thing. So, you know, if you could still do, I'll say, an assessment to see if you can match it up, it becomes more difficult. But as you said, if they claim they got it, I'm just thinking hypothetically here, at a hotel, but they also stopped at the airport, 2 airports on the way leaving somewhere and when they arrived, and they went to a restaurant, and the restaurant had misters, or they went to other places where they washed their hands and used hot water. There's lots of different exposure points along the way where someone may have contracted Legionnaire's disease, and matching it with your facility becomes more and more difficult. If you have uh, if you have a robust plan that data can show and say, "Listen, we do this testing, we do the stuff." It The data don't support us from our facility versus other ones where the data is sparse and there's a lot of data gaps that have to be filled in through ancillary data evaluation means.
You as you're talking there, I'm thinking that when a lawyer obviously they get to the point they wouldn't understand this. I don't think so. Look, I'm not making any judgment on any lawyer that's out there. If you want to write to me or anything else, and by the way, just as a legal statement, just in case anybody wants to challenge Dr. LeBeau on a Dobert challenge or anything, make sure you get the whole context to this conversation before anything else, before and after. But what I'm interested in is a lawyer necessarily wouldn't know about this. They would just look at a case and they would say, okay, so this is where the causation is. This is where they contracted it. And they're either going to defend or it's going to be a plaintiff case. But they should know. So what you're saying is lawyers should realize that there is a pattern, an intelligence pattern to location, environmental location that a lawyer should be aware of straight away.
Right, and that's what, again, kind of what I go back to understanding what an individual did a month before they're claiming they had an exposure. They'll say, "Oh, a week or 2, that's all the CDC asks." I wanna know beforehand because there may be those instances where there could be a unique part of that individual, whether they have some kind of other health problem that delayed the presentation of Legionnaire's disease, and their exposure may have happened 3 weeks beforehand. But if you limit it to 2, then you're maybe missing a week's worth of exposure. Looking at, I'll say, and I don't want to say it's alternative causes, but when as an exposure scientist, I look at things and say, well, we got to understand what the exposures were. And if you've had again, I'm throwing random numbers out there, 50 different exposures, then what is the process for linking your Legionnaire's disease to that one exposure you're claiming? How did you rule out all the other 50 in a scientific methodology means?
Now, here's the other thing that a lawyer who's then coming to you to hire you as an expert being on a defense case or anything else. What is it that the lawyers should be doing? And I want to kind of particularly lean on the whole fact of you're talking about the timeline and the speed to operation, right? Um, because I think I see in the legal industry, and we've talked about this before, there's very often a case of we're doing this, and I need you on a deposition tomorrow. I need a report done within 24 hours. What do lawyers need to know, especially in terms of a Legionella case and timeline, how they should be looking at it? What's the reality for this?
And I'll address it towards Legionnaire's disease, but I'm gonna address it towards all cases, is that or all matters in general, and I tell all my clients this, is that science is not a fast process. Don't wait till the last minute for engagement. I've seen it more and more often lately where there's a wait till the last month or 2 before any kind of disclosure or anything else to engage an expert, and we need time to understand what's going on, because oftentimes we're going to have questions and we need you to get the answers for us. And that back and forth with whatever party is going to take some time. You know that we have other jobs we're doing. I know you have other jobs you're working on. So getting us engaged very early on is beneficial for everyone involved. And again, it's not just Legionnaire's disease; it's all things. Because if you say, "Hey, I need this report, this in a few weeks, and this deposition and this trial," I've started. My first question I've started asking is, "What's your timeline?" Because so often I'll have a conversation with somebody, and I get to the end, and they say, "Oh, my timeline is a month," and I'm like, "That doesn't work. I can't do that for you. I can't help you because that's not enough time." So and again, this is beyond lawyers. It's everywhere. It's get us engaged early because again, everybody looks in CSI and thinks, oh, they can do things in 5 minutes. Science is not fast, and it takes time to
What
do
you
stuff and
see, ladies
analyze and
and
evaluate.
what you see, ladies and gentlemen, on TV and law shows and war movies and spy movies and all this kind of it's not reality.
No.
And NCIS it is not reality. And I will say this as well, in your defense as an expert, is that from all the lawyers that I know, there's a lot in help lawyer. I've communicated with many, I've met many. Their their own deadlines fail a lot of the times. They never for themselves. They're never on. If I've got a legal thing that I'm dealing with and I hire them for something, they're never on my freaking timeline either. It's always the last minute. So I'll say that even though they expect you, me as a consumer that might hire a lawyer, listen to every attorney out there. We also need it in a good timeline. So I think timelines are important to understand from the beginning to the end, everything.
Yeah. No, I agree. And listen, I know everyone's busy. I know there's a lot of stuff going on, but if it comes down to doing scientific evaluation, laboratories, even if if I send samples to a lab, it's going to take 2 weeks. So that's 2 weeks there waiting for information back, and then that limits my time even further on what I'm able to do for if it's composing a report or doing an analysis or whatever, especially if it's a month deadline. So it's just recognition of that is I think crucial.
How long, in your opinion, or probably in your experience, for any new lawyer out there that may be approached, they may even personal injury lawyers, toxic tort lawyers, they get approached for these, for this type of case. What is the timeline for the case from beginning to end? And I know you mentioned you want to be involved right at the beginning, but how long have you seen these cases last?
I well, I don't say cases. I routinely get calls that where exposures happened 2, 3, 4 years ago. And they say, "Oh, well, we've gone through these things. We've gone through, interrogatories and all this other stuff. And now we're at the point where, and it's almost like they say, well, I guess we need to engage an expert." Well, I promise that the questions that I am going to want answered, I can help out earlier than that. So, and it may, it may give some insight additionally that you may not think of, especially if you're not used to handling these types of cases.
Can you as well? Here's another thing that I'm thinking of, and primarily really for your business. Can you help attorneys learn enough so that they can get cases? Because I see there's a lot of attorneys out there. Look, the legal industry is huge. You know that. It's massive. There's so many subdivisions and so many different niches within it. But everybody's fighting for a new lead. Everybody's fighting for new business. Is this a particular growing area that attorneys should be looking at now? Legionella cases increasing, and what does an attorney need to know to be able to put themselves out there to say, I can competently deal with your Legionella case, your lawsuit?
Uh, Well, one of them would be to do enough, I'll say, sufficient background reading. A lot of times, or taking a course like a CLE or something that may assist them, because I'll say, hey, if you're interested in learning more about Legionella and Legionnaire's disease, here, read these few documents. These will give you a good basis for it. But a lot of times these folks turn over these claims to their insurance companies. So if it's if you are knowledgeable of some adjusters for insurance company, with some third party adjusters, sometimes I'll get contacted by a third party adjuster that wants me to assist and connects me with the attorney. So it's if you realize that most of the time, because they are not asking for a little amount in these. They want they look at this and they see that there's a lot of money involved. So if it's if it's getting in good with some of the insurance companies, conversely, if you are understanding that there are people that are traveling a lot and you may well want to target those groups and say, listen, if you're traveling a lot, you ever get sick, give me a call, because of the known issues with the three main, I'll say, um case categories for Legionnaire's disease are community acquired, travel acquired, and healthcare acquired. And if you're traveling a lot, if you're part of a group or something, then you're traveling, those traveling groups may be useful to get your information to them and say, if you do get sick during travel, this is a known problem.
It's a comic. I'm thinking it's a comical thing now, and I'll say that I kind of envision myself, when you drive down the I-4 in Orlando and you see the big billboards, been damaged in an accident, phone Eagle Law, and have you
Mhm.
had this? Then phone whatever it is, this lawyer. We fight for you. We're going to get to the point where there's billboards for Legionella. It says,
Well,
"Have you
well,
contracted Legionella on it? Have you been on a cruise recently? Call Hawk Law."
Well, this is the interesting thing is, I know we're talking about Legionella, but waterborne pathogens are, again, more so a recognition problem. I mean, you mentioned your friend who had Pseudomonas. There's other
Yeah.
waterborne pathogens like non-tuberculosis mycobacterium that are also problems that people are just not recognizing and not realizing, which is why now other, I'll say, consensus guidance or standards are recognizing other waterborne pathogens besides Legionnaire's disease that are also a problem. Those are even more difficult because Legionnaire's disease is a nationally reportable or notifiable disease. Those others are not.
Pseudomonas isn't.
So, yeah. So tracking them makes it difficult, which means that you don't know where they got it from. At least with Legionella, you have a paper trail almost of, where the report was and who reported it and stuff. Other ones, like Pseudomonas, may have a long incubation period. And where have you been in the last 45, 60 days? That's a lot to remember and understand. So there's a lot of points. So beyond Legionnaire's disease and Legionella, there are other waterborne pathogens that are becoming more and more not an issue because they've always there. Recognition of the issue that they are present in water systems.
Alex, is it more personal injury lawyers that deal with these cases or toxic tort lawyers that deal with these cases?
Um, it depends. I
Because
hear from
exactly,
yeah.
because there is a division. There is like,
I've seen a wide variety. Yeah, I've seen a wide variety of folks that deal with them. And again, if it's maybe some of the personal injury that don't have the knowledge here because they don't handle them. They're not at the level where they handle a large volume of them, so they may not be up to speed on the science of it. Where I've dealt with some folks that know exactly what's going on and know when to get us in and why they need to get us in and do everything that handle, maybe 5 or 10 of these a year versus maybe 5 or 10 over their entire career.
Yeah, that's a massive difference.
Yeah,
Alex, thank you for joining me today.
of
I'm
course.
excited because you're actually going to be doing a masterclass in Help Lawyer for lawyers. What would you be saying to lawyers now that if they don't know anything about this, but this is something that they want to? Why do you think lawyers should be educated? Let me go there. Why do lawyers need to be educated in this now?
These problems are not going away. Legionnaire's disease occurrence has been increasing pretty much year over year. There have been a few dips, but I think those were data issues, I'll say, during COVID and stuff, but the cases are increasing. It's not that, again, I think it's more so the recognition, but the cases are not going away. And I've said it in other places too, and I'll say it here. It's at some point in time, if these facilities don't get their ducks in a row, they're going to win the Legionella lottery. At some point, they're going to get tagged with someone claiming they had Legionella at their facility. It's not going to go away, and it's when you have maybe 10,000 cases a year and, those are the ones that are reported and known. They CDC estimates that there may be between, an additional, I'll say, 5 to 8 times that are maybe aren't recognized. I've done in my own analysis to see what the underreporting is, from CDC, year over year to kind of adjust for what's known, and they're not going away. They're gonna continue recognition, and the recognition that there's a consensus standard that has to be, and I say has to be, that there's a consensus standard that building owners and operators are aware of, and if they're not doing what I'll say, the standard organizations are bringing to their attention, it just makes it easier for them to get tagged.
Absolutely. Alex, I think it's important to recognize definitely that this is a growing problem, and it is going to be a growing problem in the legal industry, in the tourist industry, in leisure, in all sorts, and healthcare especially.
Yeah.
We're seeing more and more of these cases, and I think lawyers need to be educated, well educated for this. So I'm grateful that you're part of our network, and you're there for any lawyer who is in part of legal actually part of the Help Lawyer Network. You can reach out to Alex on his profile, but you can also get to him at exposureconsultant.com. And thank you for doing this. I know it was a kind of off the cuff thing, but I think it's an important episode that we bring out there for lawyers to understand. And we'll let everybody know if you are interested, if you're a toxic tort lawyer, an environmental lawyer, personal injury lawyer, and you want to get a breath, you want to become more educated in this so that you can offer these services to potential cases. I'm not going to ask you, Alex, whether you like to work on plaintiff or defense, because I think it's either or, I suppose.
And I will say I go where the science goes. So if there, I follow the science. That's all I do. And that's the best I can do.
Have you got a preference, plaintiff or defense? No.
The preference again. It's my preference is where the science is supportive of the scenario. I look at every different scenario. There may be some where I'll have no problem doing this. Somebody approaches me and asks me to look at the information. I'll say I don't think the science supports this outcome. Or I say, "Hey, you know what? The science actually does support this outcome. Let's figure out how to take care of it."
I love it. That's a very, very diplomatic response, but I'm excited for this new CLE and masterclass is going to be coming up in Help Lawyer. Ladies and gentlemen, thank you for joining us on the Legal Owl. Alex will be back again. We've got so much to talk about. In fact, we've got a roundtable coming up in Help Lawyer as well very soon for PFAS. So if you're a legal expert that is involved in that, then that's going to be coming up. So make sure that you attend. Thank you for joining us today on Legal Owl. Alex, thank you for joining me. God bless.
Thank you.
If you're a lawyer, then I invite you to consider joining our exclusive legal network on Help Lawyer. just send me a message and we will book a time to have a private conversation together.
You've been listening to The Legal Owl, where law meets the unseen layers of clarity, leadership, and inner alignment. If this sparks something in you, trust that feeling. Let it lead you. For deeper insights, real conversation, and strategic guidance, connect through the Help Lawyer Network and subscribe to the show wherever you listen to podcasts. If you prefer a more private connection, you'll find the path when you're ready. Until next time, stay present, think deeper, and lead wiser.